May it please the court, ladies and gentlemen of the jury, your honor, my name is Theo and I support Miss Lucy VanPelt. Ladies and gentlemen, this is a case about child's play and liability. On November 20th, 1973, Thanksgiving Day, my client, Miss Lucy VanPelt, was out in the fields playing football with her three friends, Mr. Charles Brown, Mr. Linus VanPelt, her brother, and Snoopy, just playing a little bit of football. At one point, my client, Miss Lucy VanPelt, had offered to hold the football on the ground so that her friend, Mr. Charles Brown, could practice a place kick. Now, initially, Mr. Brown had declined the offer, with suspicions that she would pull the football as he would go to kick it, which, as it happens to be, a prank that she has pulled on him many times before. However, after countless minutes of begging and the presentation of an adorable make-believe contract, agreeing that she would hold the football there for him, Mr. Brown finally came around and agreed to kick the football. Now, as you may expect, when he went to kick the football, she playfully pulled it away, and he kicked just plain air. So she's done this many times before without any dangerous repercussions. However, this particular circumstance, he lost his balance, fell on his back, experienced a few injuries, and now he wants compensation. Well, after all, it could be said that technically, though indirectly, my client is responsible for his injuries. And that maybe one might want to press charges for, I don't know, civil battery. Yes, that may seem reasonable when just quickly looking at the event, but when given the evidence in hand and then looking at the sequence of events itself, there is virtually no platform from which such an accusation can be made. So there are two key reasons behind this. The first one is intention to injure. So in any cases, particularly civil battery, but anything of this sort of circumstance, in order to prosecute, there must be proven intention to harm or injure the plaintiff. Yes, there was evidence that maybe Miss VanPelt was trying to play a prank on Mr. Brown. However, there is no evidence at all for which there can be a conclusion drawn that she was trying to hurt him. So therefore, that is ruled out. Number two is assumption of risk. So in a situation such as this, on a legal standpoint, Mr. Charles Brown would be required to assume his own risk, that maybe if he goes to kick the football, he might kick clean air. Yes, you could say he's a child. He doesn't know what he's getting himself into. However, later on, I will call Mr. Linus VanPelt and Snoopy to the platform to not only testify that he had been through the same situation multiple times before, but that there had been an explicit verbal interaction between Mr. Brown and my client in which he fully acknowledges his suspicions that she may do such a thing, to pull the football, a situation in which he clearly defines and assumes that risk. Now, given those two reasons, overall, this is just a matter of child's play gone wrong. Well, after all, the antics of a clown aren't meant for the cloistered cleric. Thank you for your time and your attention.
Nicely done. My favorite phrase has been used. That was awesome.